Good afternoon, everyone. I'm Hek Sharma, and on behalf of Guts International, I welcome all to our virtual discussion on Beyond EODB, enabling ease of running a business by bridging trust deficit. Before we dive into the exciting discussion, just setting out some house announcements. Today's session will be 1 hour 30 minutes long. The session will begin with Amol Kulkarni welcome address, followed by the release of our discussion paper titled Bridging Trust Deficit, Enabling Ease of Running a Business in India, and subsequent panel discussion. The panel discussion will be for 1 hour, after which we will be having an interactive Q&A session. So during the webinar, we encourage the panel members to keep their cameras on and their microphones on mute unless speaking. This session is being recorded and will be released later on Guts International's YouTube channel. The link for the same is in the chat box. In addition to this, live tweets will be done for this event. It is encouraged that the participants post their questions to the moderator, indicating relevant speakers in the chat box to make this session more interactive. They can also raise hands during the Q&A session and pose their questions. I now invite Mr. Amol Kulkarni, Director Research, Guts International, for this welcome address and begin the much awaited discussion. Over to you, sir.
Thank you so much, Mahek, and welcome everyone. I hope I am audible and visible to all. I have known many of the speakers personally and professionally for quite a long time, so it's great to see all old faces and at the same platform. Before we sort of dive deep into this discussion, I think it's important to understand that the government of India has been doing a lot of work on the issue of ease of doing business in terms of digitizing and reducing the number of touch points, number of pain points for businesses, and it has succeeded largely to a great extent, and credit where it's due. However, we feel that there's a need to shift gears and move from ease of doing business to something called as ease of running a business, because currently what we believe is government's focus has been to digitize and reduce formal interaction points with businesses, which is whenever there is a need for an approval, can we reduce the can we simplify the forms? Can we simplify or reduce the number of approvals which are required to start and operate a business? Or can we reduce the number of touch points in terms of shifting from a quarterly to a half-yearly or a yearly kind of compliance requirements, and digitizing everything so that there is transparency. But in our research, it has sort of it's quite evident that while this is a good way to start, but there are a lot of discretionary interaction opportunities, which the laws under which government officers operate, these laws enable government officials to create a lot of these discretionary interaction opportunities in terms of inspections, in terms of asking for information, in terms of checking for records, which leads to a lot of challenges for businesses in effectively running the business. And therefore, we think that there is a need to shift the focus from just doing the business, which is limited to starting a business and reducing formal touch points, to running a business, which is really at a day-to-day level, what are the challenges which businesses are facing when they interact with government officers, and how government officers are actually invoking the powers within different laws, and sort of perhaps unintentionally making life for businesses a little bit difficult. And during our research, we have found that a lot of these discretionary interaction opportunities do not come with appropriate procedural and substantive safeguards. It's at whims and fancies of government officers with limited kind of accountability mechanisms in place, which results in at times abuse of discretion. We understand that discretion is important for government and businesses to interact, and given the dynamicity of the business environment, and government and businesses need to work together for ensuring the best of the environment in which both these entities operate. But at times, due to lack of procedural and substantive safeguards, when such discretion is invoked, we see there is a chance to uh, abuse such discretion, which results in a lot of unintended consequences for businesses, both big and small. The second thing that we have sort of looked into is the role of government as regulator, which is different from a role of government as counterparty. Because government is also a counterparty with businesses in terms of procuring services and also providing a lot of services in terms of credit and so on and so forth. Government and government uh, owned entities. And we thought that when these two roles are fused, it is difficult for businesses to, at one hand, interact with government as another counterparty, and while knowing that government is also a regulator and a licensing authority and has a lot of more powers. So, how can we think about ways to distinguish these two roles, and perhaps technology and rewriting of laws and implementing them in a way which treats both government-owned entities and private sector at the same pedestal is the way forward. And sort of this is something that we want to discuss further as we move ahead. The third thing is that we found that there is perhaps an inverse relationship between ease of doing and ease of running a business with ease of litigation. So the more you make it difficult for the government to do litigation, the easier it will be for the business to run a business. And therefore, it is important for us to ensure that it becomes difficult for government to litigate, because that is in the interests of industry, business, and other stakeholders. And in the discussion paper that we have put out, and particularly the speakers have access to, we have put out some suggestions and recommendations into how to think about some of these issues. And without taking much time, I will just introduce the speakers for the day, with whom we want to sort of discuss some of their insights and point of views on the issues that we are covering in the discussion paper, and also maybe create some sort of a coalition to shift gears from ease of doing business to ease of running a business. The speakers for the day, we have a whole lot of representation from industry to think tanks to researchers who have dived deep into some of the issues. We'll start with Mr. Pradeep Mehta, who is founder Secretary General of Cuts International, who will be also moderating the discussion. We also have Mr. Rishi Agrawal, who is co-founder and CEO of Team Lease RegTech. His work on jailed for doing business is quite well known, and the government has taken a note of that and has been working on decriminalization of a lot of regulatory provisions. Bhuvana Anand is co-founder of Prosperity, and she's been doing a lot of work at state level to look at some of the challenges which business have faced, and particularly on nuts and bolts of doing business. Angira Singhvi Loda is partner at Khetan and Khetan, and also is associated with a lot of business organizations, and has a first-hand experience of issues and challenges which businesses and governments face when they interact with each other. Danish A. Hasim is chief of EODB, MNC, and GVC vertical at CII, and he's been tracking this issue and commenting on it for quite several years now. We all have must read his work on this important issue. Mr. Anil Bhardwaj needs no introduction. He is Secretary General of FISME. He has been voice of MSMEs in the country, and we have always benefited from his sage advice and perspective from MSMEs on some of these important issues because MSMEs are lifeblood of the country. And Mr. Jay Krasta, who is founder and chair of CM Enviro Systems Private Limited and chair of Elsewhere Eco Products Private Limited. He has years of industry experience and has deep dive into several of these issues in his several roles. So without further ado, I would like to request Mr. Mehta to provide his thoughts and also subsequently release the discussion paper, after which we can go on to hearing from other panelists. Over to you, Mr. Mehta.
Thank you, Amol. Let me just add to the welcome by Mehak and Amol to all of you to this event. And this is something which we've been thinking about for many years as to. The other day I read in the newspapers, there is a district next to Jaipur called Dausa. And there were two subdivisional magistrates who were extracting money from the highway developer. For what reason? No reason except the fact that they had the powers to stop the business of the highway contract. One subdivisional magistrate was a lady and the other was a man. And that really shocked me. He said, look, they don't have any powers to stop it. You can find 101 laws and ambiguities in our system whereby you give this kind of rent-seeking powers or exploitative powers to the bureaucracy at the lower level. And there are hundreds of such extension examples like this. And that is what led to my discussion that, look, we are talking about ease of doing business. Now, what we saw was the ease of doing business was mainly the entry level barriers which are being removed in many places, except for one elephant in the room, which I'll come to at the end, the judiciary. But that is not what we are looking at the moment. The discussion, therefore, today is of paramount importance in order to address this issue about ease of running business. In an ever-evolving global landscape where competition is fierce and opportunities abound, we must create an environment conducive to entrepreneurship, investment, and growth. So far, the attention towards ease of doing business was, as I said earlier, was merely on starting of an enterprise rather than running of one. Due to lack of trust, this is the title of our paper, debt and deterrence and accountability, enterprises continue to face hurdles and rent-seeking while operating their enterprises. The same phenomena also inflicts our ease of living. There are 101 kind of issues that we find even as a citizen to be able to get. The other day, I came across a very unique example of deterrence, which I'd like to share with this audience. It is not relating to business, but several of the candidates for the assembly elections did not file their nomination in Uttar Pradesh because of the legal remedy which is now available, a kind of legislative change which happened, that fast-track courts for MPs and MLAs was set up, and they were required to give a judgment in 1 year's time. And that was by itself a big deterrence to many of the criminal elements in politics, as the newspaper very rightly surmised. And therefore, they decided to stay out of electoral politics, but to continue in politics. So that, this is a wild example of deterrence that I thought is interesting to note. In another area of our life, which is very predominant in large number of our country, where criminal elements continue to dominate the politics. Now, let me first of all acknowledge the significance of fostering an environment where businesses can thrive. When cumbersome regulations and bureaucratic red tape hinder the establishment and operation of businesses, it not only stifles innovation, but also impedes job creation and economic development. Now, we have a very aspirational goal of reaching $30 trillion by 2047. Now, how that can be achieved unless we are able to make it very easy for both businesses and citizens to be able to live comfortably. Now, One has to streamline processes, reduce administrative burdens, remove ambiguities in laws and regulations, and enhance transparency and proportionality. EORB reforms can empower entrepreneurs to unleash their creativity, drive, and ambition and save time and costs. These reforms should prioritize addressing challenges such as corruption, sluggish decision making, undue rent seeking by government officials, numerous complex and ambiguous regulations that undermine the entire system, and the lack of accountability. This is a very major problem. I mean, this is other than the fact is that the mindset problem, of course, exists. These reforms ought to encompass the entirety of the business cycle, including engagements with regulatory authorities. Moreover, facilitating business activities attracts both domestic and foreign investment, which are indispensable drivers of economic growth. Investors are drawn to jurisdictions where regulatory frameworks are clear, predictable, proportionate, and conducive in business operations. Only the other day, the US ambassador, speaking at a session in Jaipur, entered into an argument with Amitabh Daseti, said that even today, we find many of the businesses find it very difficult to operate in India. And he was right. I mean, Amitabh retorted that it is not so, but the fact is it is so. Now, when we look at, as investment framework, it is one of the essential elements of attracting investors. By implementing reforms, we should signal to the global community our commitment to foster a business-friendly environment, thereby attracting much-needed capital to fuel economic expansion and create employment opportunities. Furthermore, EORB reforms promote competitiveness and productivity. Let's not forget the gain that we can have out of that. When businesses spend less time navigating regulatory hurdles and more time focusing on their core activities, they become more efficient and innovative. This increased efficiency translates into high productivity levels, which in turn contribute to overall economic competitiveness. By creating an environment where businesses can thrive and compete effectively, we position ourselves on the global stage as a destination of choice for investment and entrepreneurship. Today, we're looking at a very funny phenomenon. A lot of investment is going out of China, but not so much coming to India as it is going to Vietnam. Why? The answer is very simple. Vietnam, things are much more easier, possibly because it is an authoritarian state like China, where the rule of the Danda operates much more effectively than in a country like India. But however, the fact is that we are not able to. Now, Dr. Krasta also represents the Laghu Udyog Bharati, which is another small-scale industries body in our country, and we have FISME. We have two important and large small-scale bodies. The trouble is let us underscore the impact that EORB reforms can have on small and medium business enterprises, which serve as the backbone of our economy. In the Indian economy, small companies comprise 96% of industrial units. They contribute to 40% of the nation's overall industrial production and 42% of all Indian exports. SMEs play a critical role in driving innovation, generating employment opportunities, and promoting inclusive growth. However, they encounter disproportionate regulatory burden that impede their growth potential. Let me underline that. The compliance burden is high for MSMEs, with over 150 employee MSMEs facing 500 to 900 costly annual compliances. 5 states have more than 1,000 punitive imprisonment clauses in their business laws, such as Gujarat, Punjab, Maharashtra, Karnataka, and Tamil Nadu. As we heard, Rishi is working on many of these issues, and we'll hear from him. MSMEs are worse off in coping with hurdles while running the businesses as compared to medium and large enterprises who have more human and financial resources to handle. In sum, EORB reforms are not only administrative changes, they represent a fundamental shift towards creating a business-friendly environment that fosters innovation, investment, and growth. By embracing these reforms, we can demonstrate our commitment to unlocking the full potential of our economy and unleashing the entrepreneurial spirit of our citizens. Now, as I said, there was one elephant in the room, and Amol hinted on that issue about litigation. Our judicial sort of setup is still very archaic. I mean, only the other day we heard Chief Justice talking about the need to address the vacation culture and the need to address the 3 adjournments culture and so on and so forth. We are one of the worst countries in the world in terms of judicial adjudication of the disputes which happen there. Now, Government of India has set up the Special Commercial Courts Act, but the implementation is very sluggish, and I'm sure we'll hear from the experts in this as to what are the reasons as to why they are not happening. With this, let me conclude and release a discussion paper which has already been shared with all the distinguished panelists. And those who would like, it is available on our website. And what we'll do is we'll just flash the, please flash the hyperlink of this on the chat box, that people who are interested to access it, we could access it better. With that, let me conclude and welcome you all once again. Let me request Bhavana Anand to please lead it. Can we do one thing? If it's here about 6 panelists and 2 of us who would also like to chip in. If we can have quick 5 to 7 minutes remarks, and then we can do a kind of a round table and come back and hopefully get a better audience interaction as well. Bhavana, over to you.
Thank
5
you.
to 7 minutes, please.
Yes, I will try and keep it at 5 minutes and save us 2.
No, you can come back. You can share your points
absolutely,
later.
absolutely.
Right? Yeah.
Much better to have a conversation. Thank you for inviting me. Amol, thank you. I'm sure you had a part to play in the invitation. Congratulations on the discussion paper. I had the chance and with great relish read through it and learned a lot from it. Things that I don't work on, and therefore it was, sort of quite a bit of, it was a nice synthesis of several different prongs of what needs to be fixed. In my remarks, I want to focus on, sort of lingering problems that require an attitude shift or a principled shift. You were saying how MSMEs are the backbone of the economy, right? And how often the phrasing when you try and pursue reforms, particularly in states, the framing is big is bad and small is fly by night, right? So this is the binary insofar as any business goes. And so now you are stuck thinking that it doesn't matter, that we have to be in the room in order to be able, or we have to bring the danda, as it were, in order to be able to prevent both of these, sort of bad actors from rearing their ugly heads, right? The second most common pattern that you see is it's not so much that there is a disagreement on the principle of the reform, right? So, for example, Rishi, Manish Agrawal, quite a few of our friends have been talking about labor regulation reforms. Even the government talked about, sort of how to change the labor codes and so on. But despite that, there is the sense that if we do the reform and tomorrow something goes wrong, so that one edge case, sort of adverse event is guiding our approach or guiding all of our risk aversion, right? All of our reform aversion. And therefore, nothing moves forward. So how do we change our approach on this? The third, sort of phenomenon that I see a lot is government knows all and can redress all. Right? So every problem can be micro specified and a micro solution can be identified. So whether it is that there is a general law and order problem in the country and we are able to micromanage women's safety by preventing them from going into the workplace or having a list of 25 conditions. I'm giving you one example of the kinds of things that are coming up, right? Or we will specify building regulations in such minutiae that the only way to be able to know if you're in the right is to call the building inspector and have him validate it, right? So you couldn't use your architectural judgment or your conversation with an engineer to validate your choices. What I want to focus on is, sort of what can we do from this point forward and what requires a collective push. My last set of comments will be on things that I feel we need to think a little bit more carefully on insofar as the submissions of the discussion paper go. On constructive measures that must be taken as a group. The first thing I feel we must do, and this is painstaking, which is to carefully list out state by state, place by place, geography by geography, list out and then correct the growth boundaries. So I'll give you one example, right? It takes 45% more land in India to meet labor regulations if you were to create one 300-person factory than if you were to create two 150-person factories, right? How does that make sense? This math is not lining up. Similarly, I'll give you another example. We need to be able to dump some of these ideas very boldly. I don't know where that boldness will come from. Somebody has to muster up the political capital in order to be able to do this, but we have to do it. For example, in India today, women across states cannot participate in up to 39 factory processes. So just think on the one hand about, Nari Shakti, and on the counter hand, you think about the fact that women cannot participate in the factory, right? The third is we do need to write in procedural safeguards. The challenge is we will not be able to do this with a one wand. We have to write this painstakingly law by law, right? One example is fines. The way that fines for any violation are imposed, there are no guardrails on how these fines came about, right? What was the procedural map that got us from finding a violation all the way to imposing and extracting that fine? This is not clear. It varies, and there's enormous amounts of discretion in this. The fifth is we don't do opportunity cost analysis. So yes, there is one step further we have taken in saying, let's at least put down some cost of regulation. This is a good measure. That being said, what we really need is a opportunity cost measure. I'll give you one example. Our building regulations today cost us between 5 and 562 jobs per factory, or 55 lakh possible jobs across India, right? It's not a trivial number. And at least that makes you think, well, is this worth the benefits that it's purporting to give us in the standard? And the last thing that we need to be able to figure out is trying out some new public management strategies. So over the last few years, we've seen a lot of push on digitization. We've seen a lot of push on third-party certification. We've seen a lot of, sort of complaining on how repeat interactions with government are deeply painful. And I'm reminded of the passport example, where we were able to, by deploying an outsourcing strategy, solve many of that, sort of nodes of pain in that process, right? How can we deploy ideas like this to help us get to the same goals that of ease of running a business? The last thing I will say is,
Thank you, Bhumna. I think
I can come back.
your time
Yes,
limit.
sir.
So can you can come back on this.
Yes, sir.
I think you made a very good point in terms of the legislative ambiguities which needs to be cleared. I mean, in terms of the ease of running a business, if I focus more on the comments that you made, this is an important. Let me go to Anil Bhardwaj. 5 to 7 minutes. Anil?
Sure, sir. Thank you. So thanks.
Anil, you're welcome to make your remarks in 2 installments.
Okay. Right. Thank you.
So don't feel afraid that you will be left out.
Thank you for being considerate. So, sir, let me begin first of all thanking the Cuts for this opportunity, and deciding to have a discussion on this very, very important topic. Not many people are still ready to discuss this threadbare. I feel that if you look at from reform since 1991, so the entry of doing business has been eased to a large extent, and in most of the sectors. When it comes to ease of doing business, it has been eased to some extent. And when it comes to exit of business, there has hardly been any improvement so far as micro, small, and medium enterprises are concerned, MSMEs. I'll take the last part first, and then elaborate on other issues. IBCs, for example, is there since 2016, but it is only applicable to body corporates, that is companies, And 97% of MSMEs are either partnership firms or proprietorship firms. That means individuals. And currently, we don't have rules for individuals. So that means, and perhaps that is for the reason that the maximum number of people committing suicide are not farmers. It is self-employed people. There is no exit. If failure means dead end and jail or suicide. So exit is really, really bad. But currently we are discussing about doing business. And let me begin first of all with the ease of doing business itself. What I'm saying that the World Bank index was not the right one to capture the difficulties that businesses face in doing business also. And because it was limited, it had a limited scope. It did not cover most of the important issues like access to finance or infrastructure, labor laws, political stability, etc. And it had one size fit all approach. So we needed to look beyond that. That's what I wanted to say. I mean, beginning itself, especially if you are looking at the district level, say we conducted a study in Merit. We found out that almost 80% of people are self-employed, either working from unauthorized areas or from home. Unauthorized because the city rules and regulations developed later. City was old. So they had old lanes like, in Jaipur or in other cities. I mean, almost everywhere it would be like that, except perhaps 2-3 planned cities like Chandigarh or maybe Gandhinagar. But otherwise, most of the cities in India grew organically over a period of time, maybe sometimes centuries. And the recent regulations came in the last 50 or 60 years. So what happened is that, most of the areas where people are working from are quote unquote described as unauthorized. What does that mean? It means the moment authorities come to know that you are doing business from there, your electricity tariff goes up because you are considered commercial. Your water tariff goes up. You are charged double or maybe 4 to 5 times sometimes the rent of house tax. So in order to avoid that, you have to grease the palms of the authorities. But apart from that, apart from this cholesterol of doing business, the major difficulty is that the growth is stopped because the moment you are working from an unauthorized areas, access to banks and finances is denied to you, and also all the support programs and incentives that are there of the central and state government, because you are not registered and you would find it very difficult to work from there. So, I mean, it becomes a vicious circle if you are working from unauthorized area and you are condemned to work because you cannot afford to, I mean, for a large number of people, they can't afford plots in authorized Indian estates, and that would not justify their doing business also because their business may be really very, very small, micro enterprises. So in the 6.3 or 4 crore people that we say are MSMEs, almost 99%, 98 point something percent are really micro enterprises. So, I mean, this is the, can say, setting that we have. Now, what should be done? I think that I can come in the second part.
Thank you. Thank you very much. My request, Danish, you heard two people talk about, and you have your own experience of, overall experience. And what could you look at? I mean, do you have any specific experience on SME sector? Danish, over to you. 5 to 7 minutes, please. And as I said, you can come back again.
Yeah, thank you, Chairman. First of all, thanks for inviting me for this very animated discussion. And also thank you, congratulations for your discussion paper. I read it extremely, like earlier panelists said. In fact, I also learned a lot of new things from this discussion paper, very well drafted. And so just to begin with, I was just thinking, it has actually started making me think beyond this thing, what you call ease of doing business. Because ease of doing business, what I have understood so far is that ease of doing business is starting a business, doing a business, and exiting a business. And when it comes to doing a business and starting a business, there is a very thin line. You are right that government has so far focused only on starting, mostly on starting a business, not only on starting a business. But eventually what happens is that once you have put the ball in motion, then what what happens is that you have to just maintain the momentum, and then also your process of seeking approval doesn't stop. You have to actually undergo, Rishi is here, there are so many thousands of compliances that you have to comply with and all that. So starting a business mostly to do with, say, Ministry of Corporate Affairs, and you acquire a piece of land and you register it, and then so that is fine. But at the same time, there appears to be very thin line between starting a business and running a business. For example, first time you are seeking approval, but then you have to continue seeking renewal. So I am happy to say that the government over the last several years has been working on actually easing things on both fronts, running a business as well as starting a business. I can just mention some examples also. And Anil mentioned about exiting a business. I agree with him, but a lot of things have happened for large businesses who want to actually exit in terms of IBC and in terms of Companies Act and all that. But there is still a long way to go. But as far as running and starting a business is concerned, I have a feeling that government in the last, to be very fair to the government, we have set the foundations for bringing about transparency, rationalization of, say, regulatory compliances, introducing third-party and self-certification, and at the same time minimizing the scope for your this thing discretionary power on the part of the government officials. But journey has not yet been completed. There is still a long way to go. Like, for example, in trade facilitation, if I can just give you example, there is what is called faceless assessment system. So whenever you import something, you have to file a bill of entry for import, and you do not know which officer will actually assess your bill of entry in which part of the country. So it may be referred to officer. Suppose you are importing something at the port of, say, Mumbai, JNPT, and your bill of entry may be referred to, say, Calcutta. And so technically speaking, as a CHA, clearinghouse agent, you are not supposed to know which customer is going to assess your bill of entry. But actually what has happened, so far so good. I mean, there's absolutely no doubt about it. So what happens technically is that there is something which mentions about the clearinghouse agent number. So custom officials sitting in Calcutta would know which CHA has applied for this particular bill of entry, and there is his office which can always contact back. So these are small gaps, despite technology and all that. These are the small gaps that need to be bridged, and that's where actually we keep identifying such gaps, trying to fill up those gaps. But I have a feeling that things are happening at a very fast pace. Things are getting rationalized, and more importantly, government is moving in the right direction to rationalize these compliances, bring about transparency. But in my view, what is lacking, and I can come in my second part, what is lacking is centralized grievance redressal mechanism. And if you have an online centralized grievance redressal mechanism, and that is actually monitored by third party, for example, suppose you have issue related to custom, and if you raise it with CBIC, so CBIC is going to favor its officers. So it has to be actually monitored by third party, like, for example, DPIT, or suppose this watchdog also need to have, say, people from industry, judiciary, and all that. So there is a fair, assessment of the case once you register a complaint and all that, and you actually receive a right decision instead of going to the court. So overall, I would say that things have started moving, but there is still a long way to go. I can come back in my second.
Thank you, Danish. I think you informed us of a very good example of kind of accountability being. I thought if speakers could have spoken about accountability, because that does happen, that does help to move things forward, at least culturally. I mean, we've seen in many cases, at least, where corrupt officers have been posted back, and they go back because of political and caste equations also now playing a very important role in many states. So we have to be aware of that. With that, now, by the way, Bhuvana, one thing that the government of India has done is also to assess the cost of this. And since they found very ridiculous results. Danish, if you remember the study which came out from DPIT, in some states it is 5 lakh rupees, some states the same regulation costs 15 lakh rupees. So it is, and DPIT also was ashamed, was not very sure of releasing the results, except to say that, we'll have to go back to, make a proper assessment. Rishi, over to you.
Well, first of all, thank you, Pradeep ji, for having me here. It's always a pleasure talking to you and the team. Been hearing a lot of very good inputs from other panel members. We've done a lot of work in the space of MSMEs, and based on real data, I can tell you that MSMEs in general bear a disproportionate burden of compliance as compared to the large companies. Now, looking at the data, you'll see that India has approximately 63 million enterprises. Only 1.1 million are formal enterprises. So there is a leakage of 62 million enterprises right there. They continue to languish, being small, informal, disconnected to the formal institutional capital, technology, R&D, supply chain. And we have seen a lot of them languish, die a natural death during COVID. One of the root causes of this problem, and you rightly pointed out, running a business is onerous, especially for an MSME. Over the last year and a half, we have done deep research, which is data-driven on companies which are MSMEs in specific sectors. And we can actually give real data on how many specific and unique compliances these companies have to comply with. If you look at automobile, company which has to run on an ongoing basis, a small company, MSME with one factory, about 100 employees, deals with close to 500 compliances a year, unique compliances. You convert it into a pharma company, the number of compliances go to 998 a year. The government is talking extensively about formalizing the retail chains in the country. We did a research on a retail chain with only 11 different outlets. And the number of compliances, unique compliances, there were 3,182 for a chain with a single headquarter and 11 retail chains. And these stores were in 2 states, 3,182. If you want to set up an alcohol beverage company, it's about 986 compliances a year. Logistics and supply chain with one warehouse is about 648. Government is investing heavily in supply chain, especially in building warehouse capacity. Did we know that a company with a single warehouse and a corporate office deals with 648 compliances a year? An FMCG company with food as one of the outcomes deals with 831 compliances. So if you look at these numbers, the numbers are just too many. I mean, a lot of these laws, particularly the Factories Act, which governs manufacturing in the country, was written in 1948. It's called the Factories Act of 1948. Now, if you look at the 1948, the socio-economic, political, and demographic infrastructure of the country was very different. Private sector was minuscule in size. Majority of the jobs were getting created in public sector. There was no concept of FDI. The only kind of employment that the world knew was a full-time employment. There was no concept of gig workers. There was no concept of work from home. So while our world has changed, we are in 21st century, internet has penetrated and has enabled new kinds of working models. But our Factories Act continues to be from the 1948. Now I know we're working on codification and that is yet to be notified. But the reality is our manufacturers, our job creators, who are supposed to create extensive number of jobs, and you alluded to the fact that the jobs and capital is moving from China to other countries, including Vietnam. I don't think we have changed that regulatory framework. While we have moved to 21st century, the rules around doing business, the employer compliance remains steeped in the 20th century, many of them around the pre-colonial times. So that's how I would rest my case.
Thank you. Rishi, leads to 2 responses to your excellent presentation. Have you done the cost of compliance study? I mean, these hundreds of compliances that you're talking about, that may, number one. Number two is there a possibility to look at the ratio proportion of the kind of rent seeking which happens in a particular sector on the basis of the number of compliances? I mean, this is a wild sort of remark. Secondly, and importantly, this is something which you could do, is if you can compare the kind of compliances that you've seen in our industries here with, say, Vietnam or Indonesia or any other similar economy, then that would then throw light to our policymakers. Look, this is how these countries are progressing. I mean, Indonesia is a good comparable example. So is Vietnam. So is any other country similarly of this nature, which is doing well. I mean, we don't have to look at some other backward country, Nigeria, for example, or Ghana, where things are not good, where of course corruption is very high. But some kind of comparative studies, if you could do, which you are well sort of endowed and well equipped to do, would help to bring forward that in comparison, what does it mean? The 680 or 900 compliances for a sector. What does it mean for running the same plant in Vietnam, for example? That would be very helpful. With that, may I now come to Angira.
Hi.
Angira,
Thank you.
as I'm applying the same discipline to all, 5 to 7 minutes, and I will come back for another round, and you can respond to the other points also made.
Sure. Thank you so much at the first for inviting me, and thank you, Amol, for giving this platform. So I can see that ease of doing business has been duly covered with the co-panelists. Would you like me to shift over to the litigation cost and the implications thereof right away, or?
No, Angira, may I request all panelists, please look at beyond EODB. Now, we've done EODB. I mean, everything is happening. Things are happening. Of course, there are problems. Litigation is a serious problem, but that is something which, as I said, I was hoping to hear from you. Which, whether it was ease of doing business, or ease of running a business, or even ease of exiting a business, you still have, judicial problems still exist. They are not smooth. Go ahead.
So I will then.
And does it? No, Angira, the other point about this that in the kind of judicial processes that is happening, is rent seeking an important element or not? And number one, number two is what is the deterrence, and number three is what is the accountability. There are very few cases where I've found a higher court admonishing a smaller court for a stupid order. But generally speaking, I don't think this has really become a practice among the judicial system. The accountability,
Absolutely. And I do agree with you. And of course, the example that was initially given that, authorities come up with any kind of actions against the businessmen, just because they have the power to do so, is leading to undue and unfair advantage to their interest, as against the ease of business that India needs to give to have more industry in place, to have better opportunities for FDI and development. Now, what also happens is at the same time, when you come to litigation, it is very easy to litigate by the government at this stage or by the giants that a startup or an MSME is dealing with. At times, what happens is you cannot enforce your contractual rights simply because the other party will be able to fund their litigation, and you cannot, because of the simple time consuming of the lawyer cost, of all these costs involved. So a lot of other countries, when I used to practice in the UK, it wasn't that easy to start any litigation. Their civil procedure has gone an overhaul around 2 decades back. And you have to compulsorily have a settlement process or a mediation process to be built in before you can initiate any litigation against a third party. Whereas in India, to be able to bring the other party on table, litigation is the only gun that one has. So when we try and bring parties to settlement, which is a core area of my practice, we know at times that once the other party is full of ego and very powerful, you cannot do anything about it. It's an easy resort that, okay, let's file against them. They will automatically have to come and settle with us. So it should rather be the other way around, to be able to save on that frivolous cost and instead focus or deploy that cost in something more productive. That was one comment that I had. Now the other, the government has put in certain reforms in certain authorities where they've also introduced compounding, they've introduced settlements, they've also introduced pre-filing advices. So recent example is by the CCI, where if you want to file for any clarifications, you come, you file it, and you get those clarifications in advance. You can get your matters settled where you know if you violated a certain provision and you expect the government to come after you later. CCI, MC, all of them have processes for compounding of them, which in turn is not as cheap, but is cheaper as compared to litigating for that. So yes, there is a certain development that the government has progressed, but the government also now needs to strengthen this along with having strong ombudsmen in place, in my view. Because ombudsman till date has had a very crucial role to play in seeing that proper settlements are being undertaken in the banking sector. That is one sector where they're powerful. They ensure that there is no frivolous litigation that happens. So that kind of a concept can also be entertained for MSMEs and startups in different ministries. For example, in my view, IP India, for example, the trademark registries, genuinely needs an ombudsman. It is so cumbersome that half the startups die their death by the time they get their trademark registered, which in effect is very crucial, goes to the root of their branding cost, their marketing cost, everything. So why if pillars like this, if policies and principles like these are put in place at the right place and at the right time, it will save on a lot of cost for small businesses and for startups. The other thing now, this was on the dispute side of things. The other aspect which I could see your working paper does provide for is getting to beyond ease of doing business, which of course is very, very important given the kind of scenario we are in India, where we are attracting more and more people to invest in India and the ones who are working in India to grow. So Startup India, for example, Make in India, all of that. Now for that, we really appreciate the government having things move online. One doesn't get to know, as Sir rightly said, that, one doesn't get to know where the file is to avoid corruption. But in that, what's also happening is they ask you to refile, and that file now goes to some other authority. That authority has some other comments, and then you again refile. So that refiling situation or the problem doesn't get addressed. You end up filing for one application around 7 to 8 times, unless you have a lawyer involved or an accelerator involved. A person himself cannot get a clearance because the government stance will keep changing, since the file just keeps going to different people every time. So I believe that, in addition to automation, you also need to have a process where you can get clarifications duly from these offices, where, of course, it gives them discretion, but at the same time, if it's duly supervised and monitored, then people are honestly doing their job. At least in Delhi, where I practice, there has been no scenario of corruption as such. They've been very helpful in giving you clarifications if you go to them. So this is one thing. And simultaneously, the government can then push the incubators and accelerators for MSMEs and startups to be able to liaise with government on their basic requirements, because these incubators and accelerators, in my view, have done a phenomenal job in providing low-cost assistance to the smaller businesses. So if they are able to liaise with the government on their behalf, it can remove a lot of burden on the entrepreneurs, so that they get free time to focus on genuinely what is important for their business, instead of these aspects where I said, you just keep refiling, and ultimately they need to engage someone. So you might as well do it through these incubators, which is very, very minimalistic in cost. So yes, these were some of the points that I had to mention. And yes, on a lighter note, I do agree, sir, on that vacation culture that you were mentioning, but I think I can't delve into it much more because I'm also a practicing lawyer here. So yes,
No, you're entitled to your vacations. Nobody is stopping you from having a vacation, except that
the judicial vacations that you had rightly pointed out.
No, even the CJI said it again, and there is a parliamentary committee. There's a parliamentary committee which has already directed all the high courts to examine the prospects. We hope something will come out of it. Yes, sir, I'm
aware. So, I mean, they have the authority to do it. I said, as a lawyer, I might not as well speak.
No, I think an important point you made was in order to ensure that disputes are resolved, the institution of ombudsman, which is prevalent everywhere, is happening. We also have what is called the alternative dispute redressal system. People are talking about conciliation, arbitration, and all that kind of thing to reduce the burden on the courts. The trouble is that the burden on the courts continue to increase in spite of all these other, alternate avenues coming up. What has happened fortunately, something which you I think you mentioned or did, I'm not sure, the Competition Act has been amended for plea bargaining. So which means you can resolve a dispute faster than what you would otherwise, without waiting for a sentencing to happen by the Competition Commission. So that's a step forward, something which is prevalent in many jurisdictions. But I must share with you one very interesting anecdote that I heard from Amit Mitra. He used to be the finance minister in West Bengal at one time. Used to be the Secretary General, a dynamic Secretary General in FICCI. He spoke about one day about a vendor, a pushka wala, pani puri wala, who used to sell pushkas near his house, come running to him, gleefully showing a paper. The paper, he said, was my this thela or whatever that has been seized by the police. Now I have a receipt of the seizure, which means I have a license to operate. I'm sorry, Dr. Krasta, I forgot. My apologies, Dr. Krasta. Over to you. Sorry.
Thank you, sir.
Sorry, serious apologies.
No problems. Am I audible, sir?
Yes, you are.
Okay. Thank you very much, Pradeep, sir. I mean, it is a privilege to talk to all the stalwarts, especially talking about MSME. Well, as rightly stated by earlier, MSMEs are, we have, say, 6.3 crores of MSMEs contributing, say, 48% of employment and 40% of export, 30% of GDP. But here, the major apathy for especially MSME is micro, small, and medium. The small and medium, the difference is huge. Small is, say, 50 crores turnover, and medium is 250 crores turnover. Where is the justice? So that is what we are also talking about everywhere, in every forum. So that has to be changed. And whereas whatever the MSME's benefit should be only provided for micro and small. And as rightly stated by earlier speakers, the micro is 95% and 4% is small and 1% is medium. Well, now we are talking about the bridging trust deficit. Trust between whom? Government officer and an entrepreneur. Entrepreneur, by virtue of all acts and all norms, and by taking all so much of loan from the bank, he is committed for the business. Whereas same way, whether the government officer also is committed anywhere, is he responsible? Is he accountable? Is he punished anywhere? Whereas the entrepreneur is punished. So unless and until government officer is not subjected for accountability and punishment, so the trust deficit will not improve. Ease of business will not come. Anywhere, anything ease of business is done. Now, for example, ease of business is done among the chosen 190 countries. India is rated 63rd in doing the ease of business. And most attractive destination in India out of 70, this is a 79 position out of 142 countries. That's the census of 2014. So that means by and large now, almost all central government rules, be it income tax, be it central excise, GST, has been streamlined. Everything is online. Even if it is online, still there is a harassment for MSMEs. Why? Because they try to find out that he has done something wrong. Okay, even if it is proved that is something wrong, okay, he can be punished. But if he is not proved that he's done something wrong, then whether the officer is punished, only when you start punishing the officer or made the officer accountable wherever he is checking the MSME, the trust deficit will not go. The bridge between the trust between what you're talking about is a business will not go. By and large, as over a period of time, be it demonetization, be it GST implementation, be it pandemic, I think more than 30 to 35% of our MSME friends have died and gone. But when they die, there is no absolutely exit policy. There is only entry, like Abhimanyu. He knows to enter the Chakrayuva, but doesn't know how to come out. So this is the problem for MSME. Once he is entered, he is gone, dead and gone. And as rightly stated by earlier speaker, more and more MSMEs are committing suicide. Or more and more MSMEs are closing down and go through the harassment of all the closing down and they go and do for employment. Why? When you say that such a vibrant sector, why don't you help them, handle them, bring them up? When the employment is 48% in MSME, why don't you help? Ultimately, the focus of the government is employment. Government doesn't give employment, then MSME gives employment. Then why don't you support? So whereas now, although now the more than 39,000 compliance have been reduced and more than 3,400 legal procedures have been decriminalized. Very happy about it. Now take for example, Registrar of Companies rules when it is made, Companies Law is Forms Companies Act, except for CSR clause. Every clause was criminalization. Now, because we fought tooth and nail, the criminalization has been removed. Now, almost around say 3,400 legal procedures have been decriminalized. Fine, we agree with this. But the government speaks about sabka saath, sabka viswas. Where is the viswas here? It is remained only on the paper, only on the budget speech. Even in the budget speech recently, we have observed. Say last year budget speech of our finance minister Nirmala Sitharaman, there are 36 times he expressed about MSME. But at this time, not even once. Why? MSME is not noticed by Nirmala Sitharaman. Nothing is mentioned, nothing is given. When you give for infrastructure, 11,1111 crores of rupees. And for the defense, we give 6.9 crores of rupees. And for R&D, 1.4 lakhs crores of rupees. And for Nari, and for poor, and for Annadata, and for youth. When you provide the 4 pillars for budget, you have forgotten MSME. When you say Jai Jawan, Jai Kisan, why don't you also say Jai Udyami? This is our apathy. That means be it politician, be it government officials, they don't have a concern for MSME. It's only on the paper. And whatever is done on the paper is not flowing down to the grassroots level. And especially state governments. We have 31 states in our country with one central federal system. But 31 states have 31 different types of rules and regulations for our MSME. Why? So what we are requesting the central government is, let there be a MSME window, single window system, all things put under one single window so that they allow the MSMEs to grow. This is our wish. Hope the new, now, for example, now Prime Minister is coming for the third time, 3.0, and the 3.0 he has promised that he is bringing the whole country to the third position. We are happy about that. Of course, now we are the $3.8 trillion economy and crossing the $5 trillion economy, outbeating Germany and UK. We are becoming number 3. Congratulations, no doubt about it. And we are in the process, for which the contribution is from MSME. It is definitely there. So help the MSME.
Thank you very much.
Maybe in the 3.0 by Prime Minister Modi, we require the single window system for clearance MSME the entire country. So this is our wish.
Dr. Krasta, I'll tell you of a research we did on the land acquisition law, the same law which applies in all the states. You'll be surprised that among 5 states we could see very large variations in the application of the same law. So it depends upon the people there. You know, this is one serious problem. Now, even if we harmonize all the SME regulations in the country, as you suggested, will the application be similar? And somebody has to keep a track of it. There's a question from my colleague, anyway, Supriya seems to have left, from my colleague Vipul Chatterjee. His question is, should we not amend the Prevention of Corruption Act to make bribe giving legal while continue with the illegality of bribe taking, along with necessary amendment in whatever act to stipulate decision making within 30 days? Will then decisions be necessary go against the other party even if all compliances are there perfectly? Third party checking within the next 10 days on a digital platform and then punishment to that decision maker for a wrong decision. Who would like to take this question? Danish, would you like to respond to this question?
I didn't pick up the whole question. Can you just briefly mention the essence?
Is there in the chat box?
Yeah.
Should we not amend the Prevention of Corruption Act to make bribe giving legal while continue with the illegality of bribe taking?
So
See, it has not had a an effect on the whole system.
So actually, what I feel that corruption legislation, of course, is the need of the hour. There's absolutely no doubt about it. But what is more important is that we actually close or break the gaps which exist for officers to make corruption actually, and that is more important. And I'm happy that efforts are being made, leveraging technology and all that, to bridge those gaps. Of course, in parallel, we can actually initiate these kind of or pass these kind of very stringent corruption act that will definitely help. And one or two more points I wanted to cover before my time goes out. One was that retrospectivity in laws, and that opens a lot of actually provision for actually returning or filing new demands, tax demands, or it may be in any other matter as well. And there is very little attention that is being paid to this particular aspect. For example, recently you had Jan Vishwas Act passed. And so what we suggested is that now, since 182, 83 provisions have been decriminalized, it would make sense if we can actually make these provisions retrospective. And in just one go, you will, unburden the.
You mean the removal retrospective, Danish? Yeah. You mean to do the removal retrospectively? Right. Please carry on.
Beg your pardon?
I wanted to clarify that you wanted the removal to be done.
No. We wanted to introduce retrospectivity. Like, for example, the crime you had committed 5 years back, now that has been actually made, you have to just pay penalty and you will not be, jailed. So what we are saying now is that if 5 years back, if it is not a crime, 5 years back also it would not be crime, and give the option to the party if they want to settle it out of court, then it will unburden the judiciary in a big way. So retrospectivity in other laws also, like for example, income tax can open file as long back as say 1952, 1962, anytime. In fact, myself, I received the income tax demand of 2012-13. Just a couple of months back. So going back to or giving them liberty to open file as long back as say 10 years, 20 years, that gives them a lot of opportunity to actually raise these kind of demands. Then other thing I wanted to bring your attention to the fact is that implement the Right to Services Act in a true spirit. In fact, all the states have implemented Right to Services Act. So what it says is that any demand that you make from the government in terms of supply of services, that has to be actually given to you in a time-bound manner. But which state is actually making sure that you get actually the time in, services in time. So if you just implement it in true letter and spirit, what will happen is that suppose you do not get the service in time, then someone has to be held accountable for delaying the provision of the service. So that is another aspect that will make the things better. And third, and the most important thing I would mention is that there has to be some, natural and automatic escalation mechanism. For example, suppose you apply for some license or renewal or process or whatever. So if a particular officer has not cleared your file, say in 5 days or 10 days stipulated period of time, then it should automatically be raised to the next level. And then the officer concerned should actually have a reply, is supposed to reply that why he delayed actually taking decision for such a long time. So these three additional points I just wanted to mention.
Danish, let me respond to this. And this is something which we have stressed very strongly in our paper. The lack and implementation of accountability mechanisms. Absolutely hopeless. Now, if you talk about Right to Service Act, have you heard of any kind of prosecution of an officer or being reprimanded at all anywhere in the country where the act is operational? No, I have not heard of it. So that is the point which we are trying to make in this paper, is that we have to improve our accountability and deterrence. Now, deterrence can only happen if, in case good examples are made of officers being penalized. I give you the example of this criminals not standing for assembly elections because they knew that otherwise their future will be totally barred from entering into politics of any sort. This is a different example, but just to show you what can happen. Rishi?
Well, I think, Pradeepji, the focus has to be to understand the root cause of why corruption happens, rather than trying and tweaking all these endpoints of corruption. We have had criminal provisions for giver and taker for a long time. Has it stopped the corruption in the country? The answer is no. So obviously, penal provision have a limited deterrence as far as outcomes are concerned. If you look at the reasons why corruption happens, there are many of them. And one of them is that there is a lot of power in the hands of inspectors to ambiguously interpret items and acts. That power has to be taken away, right? There has to be a lot more clarity in the interpretation. We've often seen the way the law is written in India, the way it is interpreted, the way it is practiced, and the way it is enforced. There is a lot of transmission losses in these four areas. The way it is written and the way it is enforced. If you look at the delta, it is too much. I'll give you an example. Factories Act of 1948 has a provision for spittoons, provisioning of spittoons. Thukdan, as they say in Hindi. Law was written in 1948. The concept of pharma and biotech industry in the country was next to nothing. Try putting a spittoon in a factory which manufactures pharma today or vaccines today. It will lose all kinds of licenses that are required to run that company. But Factories Act, since it's a factory, the Factories Act requires it to have a spittoon. Should I have the spittoon if I'm running a pharma company or should I not? I'm just giving you an example of how there is mutual conflict in many regulations of this nature. One does not know whether to do it or you don't. If you do it, you are on one side of the law. If you don't, you are on the other side of the law. So I think one thing that we have to do is take away the disproportionate power from the inspector. If you fail to whitewash the inner walls of latrines used by contractors, you can go to jail for as high as 3 years in some cases. These laws were again written in 40s and 50s. Should you send an entrepreneur to jail because they failed to chuna lagao the wall of toilet? Does it deserve this kind of punishment? And once an inspector has access to those tools, corruption becomes more rampant. And my point there is, over a period of time, I think we have moved the needle on rationalize, digitize, and decriminalize. Decriminalization just happened recently with Jan Vishwas bill. All the participants and audience, I would want to refer them to our body of work that we put together called Jail for Doing Business, where a data-driven dissection is available for their reference. I think we've made a good start. As they say, well begun is half done. Phase 1 of Jan Vishwas has been done, and I think it has laid a foundation for subsequent efforts in this direction. But I think continued focus on rationalize, removal of duplication, removal of overlaps, removal of redundancies has to be done so that
ambiguities. Ambiguities.
Absolutely. And I think you take
the
care
Babus
of that.
Take great advantage of ambiguities.
I'd like to step in here if that's
Please,
okay.
Bhavana.
Just to supplement my old friend Rishi. A couple of things, right? I feel there is so much focus on this endpoint tweaking that it is diverting us from the real problem. So take the two examples that Rishi gave, whether it is the spittoon, whether it is these lines have to be deleted from the law. So it isn't about the punishment, it isn't about anything else. A bad law cannot be implemented well, right? And I feel we sometimes walk away from that reality. Some of these things are disastrous. You need to clean it up line by line. And this is true, whether it's building regulations, whether it's labor regulations. There is no shortcut method that is available to us that says in one quick way, we will fix it. And my humble submission is that we have to bite the bullet at some point. We will not be able to kick the can down the road on this indefinitely, right? India is growing, it's true, but it's a country of 1.4 billion people. Wo jhak maar ke bhi grow karega. It's just Indians, right? And there's no option but to grow. The question is, why aren't Indians thriving? Why is our per capita income so low when it could be much higher or ought to be much higher? So why are we still thinking poverty instead of thinking prosperity, right? So that will require this kind of serious rework, law by law, line by line, backbreaking, painstaking work, addressing all the troubles that whether it's Mr. Krasta pointing out, whether it's Bharadwaj pointing out, or of course Danish pointing out as well. So I do want to point, leave that.
Thank you, Bhavana. Sorry, carry on.
One quick reaction to Bipulji's comment, right, on services timeline, time-bound services. As Hashimji pointed out, this is a reality in most states in the country, yet nothing really happens. And I feel we misunderstand what it means to implement this well. There is no way of being able to implement something like this well. What do I mean? We want somebody to behave in good ways, but we want to penalize them for behaving in what we think of as bad ways. You cannot do the same thing with one law, right? So how will you want deterrence and you want incentive. So we have to at some point make up our mind saying, do we want to take an incentive path to better behavior of government officers, or do we want to take a penalty path towards less bad behavior of government officers, right? And this is not an easy question I would submit to answer. The reason why implementation isn't working that well is that this is really difficult. So what will a higher officer do when a file is past its due by date? In most cases, by the way, the file is not due past its due by date. On the day before, there is a comment that is raised, ye document tayar nahi hai. And it's a legitimate document. It's part of the list of things that you have to furnish. It is, and the findings will not be, sort of dramatically wrong. The findings will all be right. But the point is that there is venality, there is a risk aversion, and in the best case scenario, there is just a nervousness around if things go wrong, what will happen to me? I also don't agree that there are no consequences on officers. Every day, lower functionaries of government are hauled to court. They are suspended. They are, asked to defend their decisions on X or Y, which is what prompts this risk aversion. Saying that, let me take for example, in the Factories Act case, safety at all cost approach. I will not budge on this because अगर कुछ गलत नहीं होगा, I can always say हमने तो इंस्पेक्टर ने रिपोर्ट लिखा था, observation लिखा था. The question is whether that was necessary and whether that was opportunity cost appropriate for India. And I don't think we're asking those kinds of questions deeply enough. Thank you, Mr. Mehta.
Thank you. Thank you very much. Anil? Anil, are you there?
Yes, I'm very much here.
Please, your last words.
Oh, just a couple of quick points. One is, of course, on one issue on which we have also worked earlier, that is requirement of regulatory impact assessment for every law. And not only the existing laws, but also for the pipeline, new laws that are coming in. And especially if the need for reviewing the existing laws, the Spittoon example is there. And also the need to purge the whole lot of laws that are completely redundant and that need to be thrown out. The process goes on, I mean, in terms of purging the laws, but I think an exercise to review the current laws so far has not been done very seriously. And there are obvious, you can say, resistance from within the government and the ministries and departments who are the beneficiary of the current system, that they don't want to change there. And we have seen that happening in many of the laws. The second aspect is a need of certainly a need of a grievance redressal and a feedback mechanism. Not only just a grievance, but it could be considered as a feedback mechanism also, encompassing the district, state, and center. At the same time, I think it would be a good idea. Where it used to be the practice that every important officer, every senior officer used to dedicate a specific time for public arts, where everybody could come without a prior appointment and raise the problem. Now, this window is almost closed almost in every office. This practice needs to be opened up. Coming to the most important part, and that is the litigation. See, MSMEs are almost 15% of MSMEs are government suppliers. And there are two types of problems they face. One is on contextual litigation and other is on the delayed payment. And ultimately,
sorry, I missed that.
Delayed payments.
Delayed payment, yeah.
So for both of them, the route for redressal is arbitration. And now the problem is that even if you get the arbitration award, it is invariably challenged in courts, in higher courts under Section 34. And all kind of reasons are there. And the litigation can go on for 5 years, 10 years, 15 years. And the situation has come to such a pass. For example, a recent case has come from Allahabad High Court, where after, a case of 2016-17 of delayed payment, the judgment, all the, you can say the process was over by December 23, and the judge has reserved the judgment, but has not pronounced it. Now we are sitting in February, December, January, February, 3 months have passed. Even after completion of everything, the judgment has not been pronounced. And because it has not been pronounced, the door is closed for the the MSME because he doesn't know what to do, whether he should go to Supreme Court because you need a copy of the pronouncement. So frivolous litigation by government or completely unnecessary litigation, it goes on to the Supreme Court, and the purpose is basically to tire the MSME out, and because most of the MSMEs would die during the course of this long litigation process.
Thank you. Thank you. Can I request Amol? Amol, can you respond to Anil about the regulatory impact assessment and the procedure that we've been following for some time? Angira, I'll come back to you.
Yes, absolutely. Thank you, Mr. Mehta. And I think we have been working with Mr. Bharadwaj and his team on regulatory impact assessment. We have worked sir, with Government of Rajasthan on some in some areas to understand the cost of regulation and do regulatory impact analysis. Particularly, a few years ago, we had done a regulatory impact assessment of Rajasthan Shops and Commercial Establishment Act. And as a result of which, some of the proposed amendments which the government of Rajasthan was intending to bring, it was kind enough to sort of look into our suggestions and appropriately change them. In addition, very recently, in the previous regime with government of Rajasthan, we did there was something called as CM Rajasthan Economic Regulatory Transformation Advisory Council, which had initiated a lot of research papers, and a research paper on doing business was undertaken by us, in which we adopted a three-step approach of legitimacy, suitability, and proportionality to understand the cost and processes of key approvals and registrations and processes which businesses have to go through in the state. And we had done made some suggestions on areas like factory land acquisition and pollution control norms and so on and so forth. The report is available in public domain. I'll send it to you separately as well. But the previous regime, before it went out, it also adopted some of our recommendations, and hopefully this regime will also do that. We're also working with the DPIIT on its assessment of cost of regulation and how can we sharpen it, and hope to work with them and other stakeholders also. Thank you.
Thank you, Amol. Angira, over to you.
Sure. Thank you. So, I do agree with those archaic laws that we're still dealing with. At the same time, there has also been a very proactive stance taken by the judiciary in interpreting these laws in the way they would now stand. Of course, we do need an overhaul, revamp on all these laws. We have come a little far away by having new penal codes, new criminal processes in place. I'm sure we will now come up with the labor code and implementation. This year has been very impactful in the sense, very progressive, I would rather say, in terms of implementing a lot of laws that were pending for all the previous decades, where we've seen DPDP come into picture, which is very, very progressive, going in times. We've also seen criminal processes that have come into picture. Competition Act has come into an overhaul. Yes, we do need the labor code to accommodate the gig workers, to accommodate a lot of problems that these tech companies are facing, because we're still advising them as per the Shops and Establishments Act for that particular state, which of course has no relevance as of date because everyone's working from home. So yes, we do need that. For that, if there is an initiative that we may take together, it would be very great, because technology, fintech, technology sector is at a different level, these startups, these MSMEs, and they're having to deal with those old laws which are still dealing with how to give permission to restaurants or to basic shops, which is absolutely of no relevance. So yes, there is a movement that needs to be undertaken for this. But at the same time, I would say that the legislature is doing its work, consumer protection, DPDP, just to name a few that they have done it. given the kind of legislation heavy our country is, it will take some time, and especially the population, we have to analyze so many sectors. It is not as easy as the smaller European countries to simply do it with one switch where you're hardly dealing with maybe 1 crore of people.
Thank you very much, Angira. And for the last word, Dr. Kasta.
So thank you very much. Sir, again, by and large, almost all central government laws have been streamlined, be it income tax, be it GST, because there the trust between the bridging between the trust deficit has been almost streamlined because both are punished, entrepreneur as well as the government officer. Whereas it is only the problem with the state government laws. State government laws are still not been changed, and we suffer as far as an entrepreneur is concerned in state government laws. So that's the reason why we are requesting, because there are 30 states have different rules for MSME. So what we are suggesting with the government, in the new government which is coming in the April, May, by the central government, all laws connected to MSME has to be centralized, and it should be a single window system with the stringent laws for the both officer as well as the entrepreneur. I think things will improve with the trust deficit, and we will reach $5 trillion economy. Need not wait up to 2025. By 2024 itself, we will reach $5 trillion economy.
Thank you very much. That was a very, very good sentiment. Now over to Mehak Sharma to propose a vote of thanks. Mehak, over to you.
Yes, I just want to express my gratitude to all our panelists for generously sparing our time from their hectic schedules and willingly sharing their insights on this crucial issue. The discussions relied on the very pertinent topics, may it be women's participation in MSMEs and the regulatory and litigation related issues that are here in the system, which pose a hurdle in running business in the Indian context. So the discussion was all insightful and enlightening for all of us, and it was a delight to have you all as our guests. Additionally, I want to extend my thanks to the attendees for their attentive listening and enthusiastic involvement, contributing to the success of this event. Thank you so much.
Well, bye for now.